Hello, class. Your professor here, helping you navigate another week of the Foundations of American Law class. This is going to be a bit of an extended lecture. Hope you have some patience for me because this is something we need to work through. This class sort of blows through a lot of jurisprudence in a short period of time. And of course, it's designed to really emphasize the Christian aspects of jurisprudence. So it moves particularly fast through the other theories of jurisprudence in the Western school of thought or the British school of thought, Anglo-American school of thought, that is highly influential in our legal system and how people think about the law and the legal system in the current academy, in law schools, universities, in the West and really around the world. So I'm going to try to do these other schools of thought, some of these other legal theorists, do them a little bit of justice. Not much justice, because we just don't have the time to do them a great deal of justice. But we're going to try to frame things a little bit more extensively and perhaps with a little bit more nuance than we get from the Brock text. So you've been assigned the readings in Brock. You begin with a reading from Hans Kelsen. There's also readings in there from Posner, from Llewellyn and Holmes. But there's a lot of important legal positivists and others that are left out. We also decided not to give you the reading assignments on critical legal theory, crit theory. There's an article by Kelman about trashing. There's an article about jury nullification from a standpoint of critical race theory in the United States. We really don't go much into feminist legal theory in in the assigned readings as well. So there's some gaps to fill in, some important figures that aren't really discussed. So I'm going to try to do that in this particular lecture. So when you think about jurisprudence, and that's what we're really covering here in the readings in week 6, is jurisprudence. We're talking about sort of the philosophy of law, but oftentimes the philosophy of law comes down to the issue of what is law. How does law work? Why does law work the way it does? Where does law come from? What is the point of law? What is law supposed to accomplish? Why do we have law? A lot of these tasks that jurisprudential scholars take on is really just fundamentally trying to address what law is, or in other cases, what justice is. Any of you guys read Plato's Republic, you know the question that is the basis of Plato's Republic. What is justice? And so that is definitely within the stream of jurisprudential theory. But when we get to positivism, and that's where we start off here with Hans Kelsen, he is a legal positivist. When we get to positivism, we see a branch of legal theory that's not really concerned about what law should be about or about justice or the purposes necessarily of law. It's more concerned about just saying law is, why is it, what is it, more the basic, just descriptive tasks when we think about law. It's what the positivists are concerned with. And legal positivism, it really gets its start in the British tradition with Jeremy Bentham. Jeremy Bentham is famous for being a utilitarian. He's trying to give the greatest good for the greatest number, greatest pleasure for the greatest number. And Jeremy Bentham did not like natural law. He called it law on stilts. He did not think that did not really believe in higher law. And he is a seedbed of thought from which a lot of the positivist scholarship sprung. And the person that sort of took the baton from Bentham and focused more on law in the British tradition was a gentleman named Austin. And Austin is famously known for his idea that law is basically a gun to the head. Law is power telling you to do something. So someone has the gun, they're pointing it to your head, they're saying, Brian, go do this. It's the law. I have to do it because otherwise I'm going to get shot in the head. So a very basic view of law, to say whatever the king, whatever the sovereign, whatever the powers that be say the law is, and if they have the ability to enforce and enforce you to comply, then you have law. That was Austin's sort of simplified version of law. So when we look at the assigned reading, we pick it up with Hans Kelsen. Hans Kelsen is moving on from Austin's simplified view of positive law and asking a bigger question, which is, who gets to decide who holds the gun? So someone is holding the gun and pointing it at you and telling you to do stuff, but how do we decide who is holding the gun? Where does that power really come from? He calls it ground norm. So you can see Kelsen is continuing to move back and move back and move back and move back and say, okay, well, like a child asking you questions. Well, then why, Daddy? Why? Why does the state get to tell me what to do, Daddy? And Kelsen is answering that question with this concept of ground norm, the source power that is behind everything. And there's actually been a lot of cases in post-colonial countries, Pakistan, Uganda, Tanzania, cases that discuss who is the real government and who has the ability to make a constitution, who has the ability to replace a constitution, and what is the legitimacy of a coup d'etat and a change in power. And these cases will often cite Hans Kelsen's pure theory of law as a basis of their decision. In Uganda, the case is ex parte Matovu, kind of a hard case to find on the internet out there, but it's a very famous case in Uganda. There's the Dosso case. Anyway, there's several cases that discuss this theory about where power is coming from. So that's largely the question Kelsen is answering, the legitimacy of positivist legal power. And we don't get into HLA Hart like the deer, H-A-R-T, H-L-A Hart. And he is really the most famous positivist of the 20th century. He's passed away. He's from Oxford. And Mr. Hart sort of took the cartoon version of positivism that we'd associate with Austin and provided a much more nuanced view of positive law and how it really works. And he's famous for concepts like the rule of recognition, which is a rule that explains how you have the ability to interpret or make rules, not just saying this is wrong, but also, okay, why there's a rule that says the Senate can do this. There's a rule that says the judiciary can do this. We can think about Marbury versus Madison and sort of developing a rule of recognition. Where did the rule of recognition come from to develop the rule of recognition? Inferred from Article 3 of the Constitution, etc. You could show some positive route. You can go back and say, okay, this is where that power comes from. But for Austin, he's focused on that gray area of the law, that place where we say, okay, we know that you can't do this. We know you can't kill somebody. We know you can't do X, Y, and Z. These things are very simple and clear. But there are areas where the court applies judgment, where the court applies discretion, and is not forced to make a certain finding. We can think about all these cases in the United States Supreme Court. We've had changes in the majority opinion. For instance, famously the case on anti-sodomy laws. We had Bowers v. Hardwick, and then you had Lawrence v. Texas. You have cases that have to do with, can a juvenile face the death penalty? And an earlier case would say yes, and then a later case says no. So you have judges that are facing a legal issue, and they're coming up with different answers. So how can we explain this in a positivist system where we say the law is somehow made and the law isn't applied? This infers that there is law, yet we have judges doing different things, making different holdings with the same facts. How do we deal with this? Now, Hart would submit there really is a right answer. There really is, in the positivist structure, there really is something that should be done in terms of ruling in all these cases. Perhaps it can change over time because of the sources of power, but he thinks there is an answer that's right. This is easy to be critical of. I think he does say in certain situations you can have a window where there can be different results, and that's okay. But he really wants to stick with the point that no, there is a positivist system. There are these gray areas, but there's answers that should be arrived at. But he doesn't have any moral principle guiding him to find those right answers. And that's where you have people coming in to be critical of Hart, even in the 20th century, where we think, these ideas of justice and fairness and natural law are dying in this post-Enlightenment world. You have people like Fuller, you have people like Dworkin that are challenging sort of mechanical operation of the law and saying, no, there's for Dworkin, there's something called integrity, and decision makers are following integrity. And Dworkin, which is Dworkin, recently passed away a few years ago. Famous jurisprudential scholar, probably the most significant to come from the United States in the 20th century. After, I guess you could count Holmes early on or others, but certainly in the latter half of the 20th century, Dworkin is the most significant, I would say, from the United States. Interestingly, he's not in your index. In this book, we don't find Dworkin, we don't find Hart, we don't find also Joseph Raz. These are people that are dealing in that gray area. I think that our chapter that we cover today is more about presenting things in a way that you can digest more clearly, where we can say this is this person's view, and we can even deconstruct that view as from a Christian standpoint. I think that Hart, Dworkin, Raz, it takes a lot more work to deconstruct them. It takes a lot more work to pick them apart or to try to put them in boxes. And so I think for the scope of this class and what we're trying to accomplish, that's why we don't really dig in very deeply on those particular scholars. If you're serious about jurisprudence, I think you have to weigh in deeply and when it comes to Hart, Dworkin, and Raz, and actually read what they have to say to join the conversation where we are today. So Dworkin is famous for saying there is a judge called Hercules, and Judge Hercules exists. Maybe he's just a hypothetical judge, but he sort of should exist, and he's this judge that always makes the right decision. So for Dworkin, he believes that Judge Hercules, whenever he faces these gray areas that Hart discusses, instead of saying, I need to find the law, I know I can find the law that exists, which is more of what Hart would say. Dworkin is saying, I, Judge Hercules, will make the right decision in this gray area, relying on my own integrity to do what is right. I have this superpower bestowed on me from the gods, I guess, to find the right decision. And therefore, Judge Hercules will. And all these other judges that are out there that are not Judge Hercules, their duty is to do their best to make determinations with integrity. And if they happen to come up with different responses, well, for Dworkin, that's okay, as long as they're doing their best. We realize there's only one hypothetical Judge Hercules out there. Everyone else is striving to do their best. But if they are doing what they think is right from a standpoint of integrity, then they're doing their job as a judge. If they're just doing whatever's expedient or whatever's politically will serve their needs or whatever's easiest, then they're not making their decisions with integrity. They're doing something else. So in a way, Dworkin is very optimistic about the human element in legal process. But he's also an atheist, so he doesn't see, his optimism is not rooted in any sort of idea of an image bearer or God's potential role. It's just sort of a faith he has in humanity itself to be capable of doing the right thing. And he doesn't think that the right thing is such an abstraction that we should just ignore it. He does believe it plays a part. So when he's looking at a decision like Lawrence v. Texas, he would say those judges there were Judge Kennedy was making a decision with integrity. Yes, it was different from the decision of the judges in the Bowers versus Hardwick case. They may have been operating with integrity as well. And so that would explain why you get a different result with the same basic legal issue presented and the same 14th Amendment and same Constitution, and same laws, essentially federal laws that are being considered in both actions. So that's Dworkin in a nutshell. In terms of Roz, I think he's probably a bit much for us to unpack. In the context of this class, I would say he is a legal positivist, and he's into process. He's into law as being designed as something that is a process that follows certain rules and attempts to accomplish certain ends. But those are part of the real end is to have a resolution, to have basically a system that is going to take situations and then take the law and then take you along and give people a result that, for better or worse, allows them to move on, and they can realize that this system, if it's a good system, operates in a way that is not able to be sort of manipulated by power necessarily. That it has a certain level, I guess, like Dworkin, a certain level of integrity in how it operates, but it serves that function of ultimately resolving disputes. We can think about, King Solomon, people coming before King Solomon and the dispute about the baby. I mean, King Solomon is serving that Razian purpose. He is resolving the dispute. He actually happens to resolve it in a way that shows great wisdom, but it's not really about the law in that particular scenario. It's about he's applying his wisdom, and he's able to effect a resolution because he is the arbiter of that situation and needs to see where that baby's going to be, if that baby's going to go to this mother or that mother, or is going to be split in two. Whatever that result is going to be, he's going to have to come up with a decision that the parties are going to live with afterwards, and he'll serve that function. So that's at the core of Roz, but that's oversimplification of Raz, and there's a lot more to Joseph Raz, that's R-A-Z, than what I'm describing there. So I would say, we've talked about positivism, basically what positivism is. We've talked about how Hart is the key bridge to positivism that makes it not just sort of a cartoon-like legal theory, but adds the nuance. We see how Dworkin sort of has engaged Hart, and if you think about the latter half of the 20th century, really the debate between Dworkin and Hart is at the core of Western jurisprudence, sort of like the Lincoln-Douglas debates, before the Civil War. Another important person is Fuller, engaging in Hart and really trying to, the classic question that Fuller and Hart work through is, we always have the Hitler example, but what was the right thing to do when the Nazis were in power? Was it to follow the Nazis and exterminate Jews in death camps and do the things that Nazis were doing that we can all agree are wrong now? Was it their duty to follow those orders? Was that what law was? Or was there some other law that applies? If we're going to have the Nuremberg trials afterwards, we're going to hold people responsible for war crimes of what they did when Hitler was in power. How are we assigning culpability to them? How are we saying what they did was wrong when the power and authority they were under was saying that those actions were right, or at least required or mandatory, based on the proverbial and literal gun to the head that the Third Reich was pointing at members of the military and others that were involved. So, that debate, if we want to say it's wrong, how do we say it's wrong? Is it wrong because we just know it's wrong because an unjust law is not a law at all? Or is it wrong because the Nazis weren't really the law? The real law was the law of the world that still applied, and people were going to be held accountable to that law of the world. In jurisprudence, one of the things that has made it get very complicated is international law and the authority of sovereigns and how that works, what law applies across all sovereigns, what laws dependent on sovereign consent in order for it to be a valid law. International law has really made things quite interesting. Dworkin, right before he died, wrote a paper about that and that challenge that when in the context of international law, about how to make sure people are sort of doing the things that need to be done for the good of the planet, or that are right when sovereigns are acting self-interested ways. So jurisprudential theory has gotten quite interesting given the challenges that we face in international law. Once again, that's a huge concept that in this class we're not necessarily going to be able to, we certainly won't be able to unpack in a meaningful way, but just want to let you know that it's out there. And so one of the big, I think, in Hart's concept of law, it ends with a discussion of international law. And so Dworkin's last paper is also international law. So you can see that's sort of the final frontier for these legal theories, where things get quite complicated and hard to, the legal challenges presented by the international legal order bring up these issues of morality and what is right in stark ways versus what is right and what can be accomplished legally. All right, so those are gray areas where positivism comes back in and meets up with, and for Fuller, natural law is at the core of his, he's saying there are things that are just wrong. And an unjust law is no law at all is classic sort of natural law mantra that's credited to Augustine, some credit to Thomas Aquinas. But that would be at the center of Fuller's critique of Hart when he's talking about what to do in Nazi Germany. So those gray areas where we see morality seeping back in. Other key modern jurisprudential folks we need to take account of, is this idea of, okay, what is justice? So for the positivists, if we're back to Plato's Republic, we know that one of the interlocutors said that justice is the persuasion of the strong. That would be positivism. Power, justice is whatever the powers that be say is justice. We saw with Dworkin, he thinks there's this aspect of justice that's really about integrity, that there is something at the core that is fair and good and right in terms of justice, and that we as humans have the ability to make decisions based on these principles of justice that are out there, wherever they may come from. And then in the readings, we have something from Posner. And for him, justice goes back to Bentham. I mentioned Jeremy Bentham and utilitarianism, and saying what we want to do is provide the greatest good for the greatest number. And with Posner, that's really what he's saying. So I'm going to look at the law from an economic standpoint. I'm going to say, what creates the best incentives for the best results? How are we going to provide a legal system that is going to take what we know from economic theory and therefore do the greatest good for the greatest number? So, it's really utilitarianism that's behind Posner's approach to law. And his utilitarianism is rooted in economic theory and creating the best incentives and having the best results when you really look at data and you look at how economic factors work. So that would be Posner. Another individual that we don't address in the book when we talk about what is justice and modern theories of justice that you really can't ignore if you want to take that issue seriously and engage with where we are right now, at least in the U.S., is John Rawls, R-A-W-L-S, John Rawls. And so Rawls's theory of justice is pretty interesting, and we see it play out today in a lot of the policies, or sort of, I think Trump is pushing back against a lot of sort of Rawlsian policies. But Rawls's theory of justice was really interesting. He said, okay, imagine we're at the beginning, sort of the NFL draft of life, okay? We are there. We are going to decide what we want this world to be. We are a blank slate of laws, and we're all brought together to decide how do we want society to work? What laws do we want to be in place? And what we do in this room is we all blindfold each other. We take if we're wearing a tie or whatever we're wearing, we take it, we cover up. We can't see. And since this is the beginning of all time in this thought experiment, you don't know who you are. Are you a white male, healthy white male? Are you an African-American female? Are you someone that is blind? Do you not have the use of your limbs? Are you an Asian American? Are you a Native American? Are you an immigrant? You don't know what you are. So what Rawls says is you're facing the risk. You may be someone who has disabilities that will prevent you from having meaningful employment. So what are you going to do when you're in that room? You don't know. You could be that person that really needs help. So because of the risk you face of being utterly destitute and unable to provide for yourself, when you're designing what this legal system is going to be, you're going to make sure that particular individual is going to be taken care of, because that could be you. You don't know. And yes, it may be bad for you if you have, if you're a very intelligent person that is born in the right neighborhood, that knows the right people, you may be getting taxed higher. But you don't know who you are, so you want to make a system that is going to be, he says, we're risk averse. And so we're going to make sure we want to help those that society may not be looking out for, and maybe we'll address the past ills of society. You could imagine how maybe affirmative action can make sense in a Rawlsian view of what is justice. I think you could also offer a critique as to why that wouldn't make sense, but let's just, a lot of the social programs, a lot of the welfare net that the federal government, has provided, the New Deal, not the New Deal, but the Just Society legislation and going forward, a lot of that can be, justified under this Rawlsian view. And the big foil for Rawls would be a guy named Nozick. And Nozick, his basic idea is you get to keep what you earn. Whatever you earned, justice is that you keep it. Injustice is that they take anything from you that you earned. And he would even apply that to inheritance because it was earned by somebody else. If we take things far enough back to slavery, then we can question about, who earned what and how we want to deal with those issues with reparation, things like that. That's not where Nozick necessarily wants to go. But for him, there's a real injustice in taking anything that anybody else has earned away from them and giving it to somebody else. So you see this big split between Nozick and Rawls as to what is right, at least in our American jurisprudential history. There's arguments that are going on in Italy and France and Germany. All these other countries are having their own arguments with their own people that are making similar arguments to the ones that are being made in our Anglophone tradition, India, China, wherever it may be, Africa. But these are the ones that we, in our culture, we associate with these ideas. It's interesting. You'll see these people that we assign ideas to, but in other cultures, their languages, they may be assigned to somebody else. Okay, so those are key figures to think about when you talk about the what is justice, different ways of saying what people think is just. And now we slip back into positivism. In your reading, you have readings from Oliver Wendell Holmes, United States Supreme Court Justice, and a reading from Carl Llewellyn, prominent 20th century American jurisprudential scholar and academic. And we're in the book, and they're fairly associated with this concept of legal realism. So we started off with positivism, trying to describe the law, and this is how it works. This is why it works the way it does. This is where it gets its power. Then we say, okay, but what about these tough decisions? What about issues where there may be an aspect of morality, a moral choice? So we've gone over different scholars that address this issue of morality in the law, whether they want to call it morality or not. Justice, I guess is a safer word since people don't like to say morality. But what is justice? We talked about them. And now we kind of going back in the positive strain, legal realism is really just saying what's actually happening here. Okay, I know that this is how it's supposed to work, but how is it really working? And this is where, Holmes's insights are really good, where he says, it often depends on the facts. It may not depend on the law. It may depend on the facts. And you've heard the famous saying, bad facts make bad law, like good facts make good law. What you see happening right now in the United States Supreme Court, you see so many cases that are these different groups that have different agendas. There's Christian groups with agendas. There's civil liberties groups with different agendas. There's all sorts of groups with different agendas, and they are canvassing America to find cases that, in their view, have the facts, the good facts that can cause the Supreme Court to make a favorable decision that will have wider application for their agenda. So when you see these cases coming to the Supreme Court, you just see it time and time again. I mean, the affirmative action cases out of the University of Texas, these were chosen because the white female student that they decided to run these cases through, she just, she was doing it on her own. She was hard working. They picked her out. They said, this is somebody that we like her narrative. The Obergefell cases. There's a recent case involving special education rights and what kind of remedies you have, and whether you have to exhaust remedies under the IDEA, which, if you don't know anything about special education law, that's okay, but IDEA isn't really about money. Section 504 can be about money. And the case was about, do you have to go through the IDEA with all things in order for a student to get a claim, Section 504 monetary claim? and, a pretty abstract legal issue in a way. But they were careful to find a named petitioner who was this, sweet little girl with a disability who had this cute dog named Wonder, I think, and had, there, you look at the file, you can see the pictures of Wonder, the dog, and she wanted to go to class with her dog Wonder, tugging at the heartstrings, So you choose these files. When we think about the Obama administration and the narrative about Obamacare and what Obamacare was requiring people to purchase in terms of birth control or abortion, these sorts of things, they said, well, with birth control, you're making the little sisters of the poor, nuns. You're making them, forcing them to pay for birth control and types of birth control that they find unethical. So they're choosing that case to challenge. And then there's other cases, other petitioners, other parties that could have been chosen to fight that battle, but you choose it based on the facts. So we definitely see Oliver Wendell Holmes's and insights and the insights of legal realism at play. And I think in American law school, this is the dominant theory. We don't know what the right answer is always going to be. In law, you don't see Watson. Watson can't necessarily answer all the legal questions because there's a lot of humanity going on. There's a lot of judgment calls. There's a lot of things where you don't really know what's going to happen. It depends on who the judge is. It depends on the facts. It depends on how you proceed. It depends on who's on the other side. It depends on lots of things. And legal realism appreciates that there's no clear answer in these complex matters as to what the outcome is going to be. So lawyers have a valuable function in these scenarios because they can determine and drive outcomes, and their assessment of strategy that goes beyond just saying what the law is very important as people navigate these legal challenges. So legal realism, I think, is true. And it is sort of necessary for lawyers to understand where their value comes from. If lawyers were simply out there to say, yes, I know the legal answer to that question, then, Watson could replace all the lawyers. But there's something else. There's a lot more going on than just saying this is the right answer. We can find the right answer. Then the question is, what do you want to do with it? And then, of course, there's answers that aren't, we don't know what the answer is yet. A lot of places in the margins of law. So that's why, legal realism has become something that a lot of American law graduates from the last 50 years, 60 years, they're legal realists and they don't even know it. But the legal education process requires you to sort of break things down, look at two cases with two different results and say, why is that the case? Look at the majority opinion, look at the dissent, see how two judges could come down two different ways. And that's at the center of how to, as they say, think like a lawyer. I think legal realism is a big part of that. So I think when we want to think about a case that's like a great example of legal realism, it would be the Bush versus Gore case. So anybody that had been following the Supreme Court knew that the conservative justices typically took the position of let the states do what the states do. We don't want to be intervening all the time as a federal judiciary and making states do certain things. We want to let them do to make decisions, to have a certain level of autonomy. We don't want to be activist judges controlling state actors. And then on the liberal side of the slate in the court, you had judges that were much more likely to intervene and tell states, no, states, this is an answer for us to provide. We are going to tell you what's right here. We are going to strip away more of the sovereignty from the states and give more control to the federal judiciary, issue after issue. So you had these two blocks of judges that tended to go at things from those two directions. Then you had Bush versus Gore, and you have would-be President Bush, seeking to have the Supreme Court intervene and shut down the election process in Florida. Florida was continuing, as you know, trying to go on with counting and trying to figure out who actually won the state of Florida. The election hinged on this process. Bush goes to the Supreme Court and says, stop this process. And the Supreme Court says, yes, we'll stop it. And they stopped it, and it was over. And the ones that stopped it were the conservative judges who typically wouldn't do something like that. And the liberal judges who typically, would be seen as a group that would do something like that were on the other side. And the liberal judges made the point very clear that, hey, this is exactly what you're always telling us to do, and now we're doing it. And, of course, the majority didn't need to complain as much because they were actually getting the decision they want and getting the president elected who would continue to put judges on the bench that aligned with their ideology. So when we look at Bush versus Gore, if we see, I'm sure that Oliver Wendell Holmes was laughing in his grave, just saying, ha ha, this is exactly what I'm talking about. These decisions aren't based, Justice Scalia can talk all he wants about his jurisprudential principles and how he applies them. But when it comes down to it, it's about power. It's about making a decision that's in your best interests. So that's legal realism. I want to move on now to what's not in your reading, which we talked about. I've talked about at the beginning, this critical legal theory, CLS, crit theory as some call it. We have the Kelman article on trashing, and then it morphs into critical race theory, and then feminist legal theory often has a lot to do with this. And in order to understand these lines of jurisprudential thought, you ultimately have to understand Marxism, or at least the modern academic version of Marxism. Marxism as Marx probably imagined it is not really what people deal with these days when we talk about Marxism, but it's something a bit different in the academic context. But this Marxist idea, and when it comes to law, at the core of it is the idea that law is simply an implement, a device, a mechanism for the powerful to exert control and do what they want. That really the law in a large sense is sort of a sham, just as religion is the opium of the people designed to kind of keep everybody happy and less concerned about what's happening in this world and accept what the powers that be demand of them or give them. Law is also something that there's no integrity to it. There's no justice to it. It is simply something that those that are in power are using as a mechanism of control. It's better for the powers to be to get people to think that law is just, that law is fair. It's nice for them to believe in that, so they're going to want people to believe in that, but it's something that's just there to manipulate people. So a great example of this is, which is really called reification. An example of this given by another paper, it's not, I don't believe it's in your readings, but no, by a crit legal theorist, is the pledge allegiance to the flag. Why do we pledge allegiance to the flag? And of course, a lot of the debate we have about pledging allegiance to the flag is about whether you can say under God or not, and we should keep saying under God, and it's right. And other people say don't say under God. And people have, we, especially from a Christian perspective, we may think of the pledge in the confines of that argument. But this argument about reification is the pledge is there to basically brainwash you into patriotism. we're going to take these young children, we're going to get them to stand up and just say, I pledge allegiance to the flag, United States of America, and to the republic for which it stands. And as you repeat this mantra, and as you hold your hand there, and as you stand up, that what the powers that be are doing is they're exerting their control. They're basically getting you to buy into patriotism, getting you to buy into an idea of a country. These CLS scholars will say, well, what is a country? It's a construct. So we're trying to reify these constructs and these systems that keep the people down, that keep the people doing what those that are in power are telling them to do. And so just like the Pledge of Allegiance serves that purpose of reification, in the legal system, we have people, people in robes, people in the British system with wigs, judges up high. You see this in the British tradition, other traditions. You put the judges way up high, looking down. In the British tradition, you put people in the dock too, so they're also up high in this little box off on the side, not in a place of power, but almost as a spectacle, in an uncomfortable spot over at the side, the dock. But they would say, a critical legal theorist would say, this is all done to reify the judges, to make them seem powerful, to make them seem like people we should listen to make them seem like people we should obey. So you can imagine if the critical legal theorists are coming at things from this standpoint, they really are part of that positivist tradition that the law is the persuasion of the strong. Well, actually, justice is the persuasion of the strong. And the law is a mechanism for persuasion. It is something there to be used for the strong to get what they want. So if this is all law is, and law doesn't have any moral legitimacy or any integrity, like Dworkin would say, if law is just there to maintain power and control, then you can see how critical legal theory would translate well to critical race theory or feminist theory or queer theory, because the idea is these powers that be have their agenda. Okay, we have our agenda. Our agenda is to promote the black race. How are we going to promote the interest of the black race knowing that the legal system is a sham? Well, one thing we're going to do is we're going to tell everybody that it's a sham. We're going to tell our people that it's a sham so that they don't feel like they need to respect something that isn't legitimate and is there just to control them. And then we are going to try to think about ways, if it's all about power, that we can exert our power within the system. You had the jury nullification article you didn't read as an example. There's an opportunity for power. If you don't want to see more African Americans going to jail at a disproportionate rate as everybody else, then when you're an African American serving on a jury, you can simply find African Americans not guilty, and then you can exert power within this system. Maybe this jury system is there to reify the legal system, to make it seem fair by making people feel like they're part of a process, and the powers that be are willing to use the jury for that purpose. But you can turn it on its head by saying, okay, we're going to use this window of power that's been given, and we're going to abuse it and do whatever we want to address this larger ill, which is the disproportionate criminalization of African Americans. With women, you can say, okay, what is this system that's been built? If the powers that be are men, how have men constructed the legal system in a way to maintain male power, to make things operate in sort of a male-like way, maybe more confrontational, more paternalistic, whatever it is that is sort of male? How can we as women say, let's make the legal system more representative of female sensibilities? Let's strip it away from this sort of male death grip on the legal system. for the hundreds of years that men made the laws and men made the system. How would we make the system different if we were women? How would we respond to a system that has been designed to maintain male power? What changes need to be made? You can think about, and queer theory in the same way. So you could think about it in terms of if you were representing the interests of immigrants, how would a legal system that is exploiting immigrants, how would you want to change it? How do you want to bring that to people's attention? How would you want to delegitimize it? And we can see that right now. We talk about this debate about sanctuary cities or things like that. We as a city, we think these laws are unfair. We're not going to enforce them. Okay, we've been convinced that the way these laws are operating aren't right, so we're not going to follow them. And then the federal government has to come in and point the gun to the head and say, no, classic positivism, no, we're going to take all your money away unless you play by our rules. But you see these dynamics playing out, and they're rooted in legal realism. They're rooted in critical legal theory, where there is, when it used to be, the idea that we won't follow the law, or particularly that a city wouldn't follow the law, that a government entity in the United States, a city, would say, we don't really care what the law says. We're going to do whatever we want. Obviously, we had the Civil War. We've had instances, but in general, it was understood cities are going to do. We had the Civil Rights Movement. We had resistance in certain. We've always had resistance in certain contexts, but the idea that we're just not going to do this, and it's almost ho hum. It's not about, bring down the federal troops to allow the Little Rock Nine to go to school, or have the Battle of First Manassas and Bull Run and have a war. This sort of resistance and this idea that we can choose what laws we want to enforce. We even really saw it with the Obama administration saying, with criminal laws, hey, we think these laws are too harsh, we're not going to enforce them. Hey, with these immigration policies and rules, we're just not going to enforce them. Really vestiges of, or not vestiges, but real life applications of critical race theory. And then you have Jeff Sessions coming in at Attorney General saying, no, we're gonna follow the law. A resistance that the law says what it says, that's what the law is. And so this is a core of a lot of the legal debates that are going on right now. It's not about necessarily, is this law right, or what is the correct law, or make a finding as to what the Constitution says. Lots of times it's about, these are laws we're not going to enforce, or these are laws we are going to enforce. So we are really in this realm of critical legal theory, where people are just making these arbitrary decisions as to what the law is, as opposed to really trying to, as like Hart would say in his theory of the rule of recognition, trying to determine what the law is. It's not about making a determination in these cases. It's just saying, hey, we don't like it, we won't do it. Or we think it's unjust for these reasons. Yeah, it's legal, yeah, it's constitutional, but we think that it doesn't serve the interest of particular groups that we're concerned about and that maybe have been marginalized or treated unfairly, and therefore we're going to take our own approach with respect to these laws, which our approach is we're just going to disregard them. So, of course, now we're having a lot of sort of backlash where these laws that weren't enforced are suddenly being enforced, and I guess not backlash, but just it's creating strain because how is people get used to the government acting one way and then it acts another way, and we can imagine the government acting a very different way another 3.5 years from now. So it's very unsettling when you see this approach to law borne out within the political powers that be. It definitely to look at something like the approach that Raz would have, what the function of the law is questioned. If one of the functions of the law is to create order and to create a consistent system of resolving disputes and create some sense of expectation of results, if you have different regimes that are disregarding the law for their own political reasons as opposed to based on any kind of legal understanding or process, you've got a chaotic system. And that's why I think a lot of people are feeling that sense of chaos, and it's a product of what people have been fed in American academia for the last 40, 50 years, and this sort of neo-Marxist thought. It's the chickens are coming home to roost in a way, and it's very unsettling. When we deconstruct our structures, there are prices to pay, not just when we deconstruct religious beliefs, when we deconstruct legal structures. So that's my take on critical race theory. Like I said, we've covered a lot of ground. I'm looking down at my little clicking clock at 55 minutes. I know I have said a lot in an hour. We've covered a lot of ground. This is not here for you to be tested on. This is not here for you to master everything I've said. The purpose of this talk is to give you the sense and understanding that there's a broader conversation going on here and a more nuanced conversation going on here. And when it comes to jurisprudence, then we're simply covering within the confines of this course. So I encourage you, if you want to enter this debate, if you want to enter this this sort of zone of thinking, go get yourself H.L.A. Hart's Concept of Law and read it. Read some of the books by Ronald Dworkin. That'd be a good place to start. You can read some John Rawls as well. So that would be my suggestion to you if you are interested in these areas. Don't just take what I'm saying for granted, but pick some of these fundamental books off the shelf and read them, and then you can start coming up with your own thoughts. And as you read the Mayer article, I think that's what you see. You see an individual in John Mayer, who I also interviewed for one of the lessons in this course. But you see someone in John Mayer who said, I'm going to take the time, I'm a practicing lawyer, but I'm going to take the time to actually dig in and enter this debate and enter into an understanding of what's going on with legal thought today from a theoretical and academic standpoint. So he read his Hart, and he read his Dworkin, and he read many others, and he was able to enter into the debate in a meaningful way and write an article that I think provides some very excellent insights for Christians as to thinking about how Christianity can matter in legal jurisprudence and in legal systems. And as we've heard, if you've heard this lecture, I hope you have not been thinking of it solely just as like a bunch of information, but as you think about it as a Christian, when we talk about what is justice, I think a Christian perspective of what justice is legitimate. It's not something that given where the debate is and what other people's positions are as to what justice is. You have Ronald Dworkin saying, I just know it's out there and I've got a hypothetical judge, and that judge is really going to rule with integrity, and whatever he does is going to be right because he's got the sense of integrity. How is that more legitimate than a God that has created the universe and has also created a moral order and has revealed it to us? I mean, to me, that's a lot less abstract and hypothetical than Dworkin's Hercules. Yet Dworkin is a darling of secularist thinkers and others, and his views are seen as highly legitimate, whereas many of these Christian viewpoints are seen as backwards or dated or illegitimate in the current debate. And I think that's just a matter of it's an unfair bias. And I think that Mayer's article does a good job of bringing that out. And then when we think about critical legal studies, critical theory, if we care about Christian principles and we care about Christianity, we can take the same approach and deconstruct the systems and the powers that be and look at it from a Christian perspective and say, this is the way we want the legal system to work as Christians, just as people can take apart the system because they have a queer agenda or a feminist agenda or a African-American agenda or whatever, pro-poor agenda, a immigrant agenda, whatever it can be. I think that if we see what the Bible is calling us to in terms of political order and justice and fairness, we read the Old Testament writers about what's important in society, and we say these are the things that need to be our compass and direct us as we engage. I think that this critical legal studies approach offers opportunities for Christians to take a radical approach to justice and the law as well, or at least maybe not radical, but certainly one that is purposeful in terms of gaining traction and making an impact in society, as opposed to simply standing on the sidelines and saying this is how we think things should be, and we have the right to believe in the things we want to believe in, as opposed to we think society should operate this way and we want the system to reflect how we would like society to operate. That is legitimate, because power is controlling the legal system, and there's going to be some power and control. So why not, as Christians, see the system for what it is and look for ways for what Christians value to actually matter in terms of policy and the way the legal system is working. So, like I said, I guess I'll apologize one more time. I know that's a lot. I hope it makes sense. I've really enjoyed your comments so far. I think people have been really digging in the reading material and taking this class seriously. I really appreciate that. If this talk raises questions for you, concerns, you want me to point you in further directions, you have an interest that you want to explore, please contact me. I'm here for you. I'm your lecturer. I know it's all virtual, but I'm here for you, and I want you to get as much out of this class as you want to get, because it really knows no limits. It's really a question of how busy you are in your life right now. But the content this class explores is really rich, and hopefully your interest is sparked somewhere, some way, somehow, as you think about what law is and what role Christianity can have in law. So I think that may be the last lecture you're going to get from me this semester. I wish you all the best. If there's issues that come up, I may add an additional memo, but I look forward to getting your final papers in this class and all additional papers that are coming along the way. I hope you've enjoyed the class and the process, such as it is. And like I said, in terms of the comments, the message board, I think you have been making a great use of that and made the class come alive that way. So I really commend you for making that part of the class count and really building a learning community with your colleagues. So thank you for taking the comments seriously and engaging. And thank you for being a part of this class. God bless.